Our nation's state courts have been upholding our rights and liberties for hundreds of years. They honor tradition but lead in innovation, and they never stray from their founding principles. Established in 1787, when our young nation's most iconic statesmen gathered in Philadelphia to hammer out a new government for a new nation, arguments ensued, with different sides wanting different governing powers. But one principle was shared by every person in that room: a guarantee of individual rights and liberties in the new United States of America. And how would these rights forever be protected? Through an unbiased judicial system that would review the actions of the executive and legislative branches of government. Should either of these branches meddle with any of our individual liberties outlined in the newly minted Constitution, people could come to the courts to be heard. Today, nearly 250 years later, the courts still have our backs. Yet when we think of the courts, we usually think of the high-profile rulings handed down by the Supreme Court of the United States. But you should know, it's the state courts that do the lion's share of the work. In fact, 96% of all court proceedings take place in state courts. And it's not just criminal cases. Our state courts handle everything from housing disputes to family issues to business transactions. For an institution that does so much for us in our daily lives, it's amazing how little we know about it. Let's take a closer look at our country's state court system and how it works to protect us. Most states operate with different levels of courts, including trial, appellate, and Supreme Courts. Cases begin in a trial court, where civil disputes and criminal cases are filed. These cases can be decided by a jury or by a judge, who make fair and impartial decisions based on facts. Yet our wise founders knew that more would be needed to ensure that the courts remain forever accountable to the Constitution and the law, and not to politicians and special interest groups. So they built in safeguards like the appeals process. If a person believes errors were made in his or her case, they may appeal to a higher level court. The founders also insisted on openness, meaning court proceedings, court records, and judicial decisions are open to the public. The courts stand proud of their unique position of making decisions based on law, not public opinion, of being fair and impartial, of being accountable to the law and the Constitution, and of always being open to the people. And this is exactly what our founders envisioned for us: a government by the people, for the people, and a court system to guarantee that this will never change. To learn more about your state courts, please contact the National Center for State Courts at ncsc.org.